Section 1. The myth of automatic loss. Are you a dual citizen? Do you hold a U.S. passport? Do you hold a passport from another country? If so, you might have heard a worrying myth. It's a story that circulates in online forums, in community whispers, and even in family conversations. The myth goes something like this. By simply having or using your other citizenship, you are putting your U.S. citizenship at risk. People believe that voting in a foreign election or serving in another country's army could automatically strip you of your American identity. This idea is powerful because it taps into a deep-seated fear of losing one's home and rights. The reality, however, is much more complex and far less frightening than the myth suggests. The U.S. government does not actively seek to revoke the citizenship of its dual nationals. Losing your U.S. citizenship is not something that happens by accident. It is a serious, rare event that requires a very specific set of circumstances. The law is designed with a presumption that an American citizen intends to remain a citizen. This principle is often lost in the noise of misinformation and anxiety, leading to unnecessary stress for millions of law-abiding dual citizens. This gap between myth and reality is where our journey begins today. We will peel back the layers of legal jargon and historical precedent to uncover the truth. The central question, not just, can you lose your citizenship, but what does it actually take? The process is not automatic. It is not arbitrary. It is based on a key legal concept, intent. You must voluntarily perform a specific act with the clear intention of giving up your U.S. citizenship. Without that intention, the acts themselves are often not enough to strip your American status. We will break down exactly what those specific acts are. We will look at the laws that govern expatriation and explain the term expatriation. We will examine how U.S. policy on dual citizenship evolved over decades, moving from discouragement to tolerance. Understanding this context is crucial. It explains why scary stories are often based on outdated laws or misunderstandings. Our goal, replace fear with facts, providing you with the clarity you need to navigate your life as a dual citizen with confidence. Section 2, which are why we worry and what we'll uncover. The anxiety surrounding dual citizenship and the potential loss of U.S. status is perfectly understandable. For many, U.S. citizenship is more than just a legal document. It represents a connection to family. It represents a foundation for a career. It represents a sense of belonging and security. The thought of having that cornerstone of your life taken away is terrifying. This fear is often magnified by the complex and sometimes confusing nature of immigration law. When the rules are not clear, it is easy for worst-case scenarios to fill the void, creating a climate of uncertainty for many individuals and their families. These worries are not born in a vacuum. They are fueled by historical policies. They are fueled by high-profile legal cases. They are fueled by anecdotal information shared online. In the past, U.S. law was stricter, and certain actions did lead to a more automatic loss of citizenship. While the laws have changed significantly, the memory of that stricter era lingers. People hear stories about someone's grandfather who lost his citizenship after serving in a foreign army during World War II, and assume the same rules apply today. This blending of past and present creates a distorted picture of the actual risks involved for dual citizens in the 21st century. To bring clarity to this important topic, this essay will guide you through the essential information you need to know. We will start by defining what dual citizenship means from a U.S. legal perspective and how the government officially views it. Then, we will dive deep into the specific laws, particularly Section 349 of the Immigration and Nationality Act, which outlines the potentially expatriating acts. We will explain the critical legal test of intent, showing you how the government determines whether someone actually meant to give up their citizenship, which is the most important factor in these cases. Finally, we will move from theory to practice. We will debunk common myths by examining real-world scenarios voting abroad using a foreign passport. More importantly, we will provide you with concrete, practical steps you can take to protect your U.S. citizenship and avoid any potential issues. By the end of our discussion, you will have a clear, fact-based understanding of the subject. You will learn that while losing your U.S. citizenship is a serious matter, it is an outcome that is almost always within your own control, not something that can be taken from you by mistake. Table of Contents, Part 2, Act 1, What is dual citizenship? About 4 sections. Section 1, the basic definition. Section 2, How the U.S. views dual citizenship. Section 3. The pathways to becoming a dual citizen. Section 4. The core. Legal concept. Intent. To relinquish. Section 1. The basic definition. At its most fundamental level, dual citizenship is quite simple. It means that a single person is legally recognized as a citizen by two different countries at the same time. This individual holds the rights and also the responsibilities of citizenship in both nations. For example, you might have the right to vote. You might also have the right to work or the right to live in the United States or in another country like Italy or Mexico. This status isn't a special class or a unique visa. It is the simultaneous possession of two distinct national identities. Each country's laws operate independently. One country grants you citizenship based on its rules, and the other does the same. Dual status can feel like having a foot in two different worlds. Each world has its own laws, its own cultural norms, and its own expectations. As a dual citizen, you are entitled to carry a passport from each country. That can offer major advantages: greater freedom of movement, broader opportunities for employment, and expanded access to education. But it also means you are subject to the laws of both countries, which can create real complexities. For instance, you might be liable for taxes or even mandatory military service in both nations, depending on their laws and any treaties. Dual citizenship is not governed by a single universal law. Each country decides for itself whether it allows another nationality. Some countries are open to it, while others have strict prohibitions. The United States is one of the nations that permits dual citizenship. The U.S. does not require its citizens to choose one nationality over another. So if you are a U.S. citizen and you qualify for another country's citizenship that allows dual nationals, you can legally be a citizen of both without issue from the U.S. government. That is the legal reality acknowledged by U.S. law. You are not breaking rules by being a citizen of another country, in addition to the United States. That foundational fact often gets lost in fear and misinformation. The U.S. recognizes that many citizens have ties to other nations through birth, ancestry, or personal choice. The system is designed to accommodate those global connections, not to punish them. Section 2. How the U.S. views dual citizenship. The official stance of the U.S. government on dual citizenship is tolerance, not active encouragement. The State Department acknowledges dual nationality is a fact of life for many Americans, and it doesn't prevent someone from being a loyal, law-abiding U.S. citizen. No U.S. law explicitly mentions dual citizenship or forces a choice. The government recognizes people may acquire foreign nationality automatically, for example, being born abroad to American parents. However, this tolerance comes with expectations. When you're in the United States, the government expects you to act solely as a U.S. citizen. U.S. law requires citizens to use their U.S. passport to enter and exit the country. You cannot present a foreign passport to U.S. immigration officials when returning home. While in U.S. jurisdiction, your primary allegiance and identity are to the United States. That doesn't diminish your other nationality but ensures clarity and adherence to U.S. laws. Historically, the U.S. once viewed dual allegiance skeptically. The government previously discouraged it as a source of conflicting loyalties. That led to stricter laws making it easier to lose U.S. citizenship. Then landmark Supreme Court decisions in the mid-20th century changed things, most notably Afroyim versus Rusk in 1967. The court ruled citizens have a constitutional right to remain citizens unless they voluntarily relinquish that status. That ruling is the bedrock of the modern U.S. approach to citizenship. Today, State Department policy reflects that evolution. It notes possible problems, such as dual tax obligations and competing claims for military service. But it does not treat dual nationality as an act of disloyalty. The guidance says the U.S. does not endorse dual citizenship, but acknowledges its existence and has specific rules to manage it. Understanding this nuanced position, permitted but not promoted, is crucial. It explains why the government sets specific requirements while still allowing ties to another nation without fear. Section 3. The pathways to becoming a dual citizen. People become dual citizens through several common pathways. Often the process is automatic and needs no action. The most common way is through birth. If you're born in the United States, you're automatically a U.S. citizen. This is called jus soli, the right of the soil. If your parents are citizens of another country, that country's laws might also grant you citizenship at birth. That's jus sanguinis, the right of blood. Example, a child born in New York to two Irish citizens, U.S. by birth, and potentially Irish by descent. Another primary pathway is ancestry. If your parents were citizens, you may claim citizenship. If your grandparents were citizens, you may claim citizenship. Even if a great-grandparent was a citizen, some countries allow claims. This is common in European nations like Italy, Ireland, Poland. Example, an American finds eligibility for Italian citizenship because their grandfather was born in Italy and never renounced it. They gather documents and apply through the Italian consulate. If approved, they can become a dual U.S. Italian citizen. Marriage is another route to dual citizenship. Marrying a citizen can make you eligible to apply after meeting residency rules. Requirements, length of marriage and residency, vary widely by country. Example, an American marries a Spanish citizen and lives in Spain for 1 year, may be eligible to apply. If the application is approved, they'd hold both U.S. and Spanish passports. Finally, naturalization. The legal process for a foreign citizen to become a citizen. Many immigrants take this path to become U.S. citizens. When someone naturalizes as a U.S. citizen, the U.S. does not require formal renunciation of their previous citizenship. The oath of allegiance mentions renouncing foreign allegiances, but the State Department says the oath alone doesn't strip other citizenships. Whether you lose your prior citizenship depends entirely on your country of origin. Some countries automatically revoke it upon naturalization elsewhere. Section 4. The core legal concept. Intent to relinquish. To truly understand why losing U.S. citizenship by mistake is so rare, we must introduce the single most important legal concept in these cases: intent. Under current U.S. law, the government cannot strip you of your citizenship unless you have voluntarily performed a specific act with the clear and unambiguous intention of giving up your U.S. citizenship. This principle is a powerful safeguard. It means that your state of mind matters just as much as, if not more than, your actions. The burden of proof is on the U.S. government to demonstrate that you actually intended to stop being an American. This focus on intent is a direct result of the Supreme Court's decisions that reshaped U.S. expatriation law. The court established that citizenship is a fundamental right protected by the Constitution. It cannot be taken away lightly or for trivial reasons. Therefore, the law now operates under a legal presumption that a U.S. citizen intends to retain their citizenship. This means that when a dual citizen performs a potentially expatriating act, becoming a citizen of another country or voting in a foreign election, the U.S. government will assume they did so without any intention of relinquishing their U.S. status, unless there is clear evidence to the contrary. So, what constitutes evidence of intent? It would have to be something very explicit. For example, if you were to naturalize in another country and simultaneously sign a document for the U.S. government stating, "I am taking this action with the express purpose of renouncing my United States citizenship," that would be clear evidence. Similarly, making a formal declaration to a U.S. consular officer abroad that you no longer wish to be a U.S. citizen would demonstrate intent. Casual remarks, online posts, or the simple act of using a foreign passport are not considered sufficient proof of your intention to relinquish your citizenship. This brings us to the formal process of renunciation. The only way to formally and voluntarily give up your U.S. citizenship is to appear in person before a U.S. diplomatic or consular officer at a U.S. embassy or consulate outside the United States. You must sign an oath of renunciation after a consular officer determines that you are acting voluntarily and fully understand the serious and irrevocable consequences of your actions. This is a deliberate and solemn legal procedure. It is designed to be difficult to do by accident, reinforcing the principle that losing your U.S. citizenship is a choice you must make consciously and explicitly, not a penalty that can be imposed upon you unexpectedly. Section 1. The Foundation. Section 349 of the INA. To understand the rules governing the loss of U.S. citizenship, we must turn to the primary law that addresses this issue, the Immigration and Nationality Act, or INA. Specifically, Section 349 of the INA is the cornerstone of U.S. expatriation law. This section lists the specific actions that can potentially lead to the loss of one's citizenship. It is the legal foundation upon which all cases of expatriation are built. However, reading this law in isolation can be misleading. Section 349 does not operate in a vacuum. It must be interpreted through the lens of major court decisions that have shaped its application. When you first look at Section 349, it presents a list of 7 actions. These actions include obtaining naturalization in a foreign state, serving in the armed forces of a foreign state, taking an oath of allegiance to a foreign state. In the past, performing one of these acts was often considered sufficient on its own to trigger loss of citizenship. The government didn't need to prove much beyond the act itself. That older interpretation fuels many persistent myths and fears. The modern interpretation is fundamentally different. Today, the law has 2 essential components that must be satisfied to lose citizenship. First, the person must voluntarily perform one of the listed acts. Second, they must do it with the specific intention of relinquishing U.S. citizenship. The intent test isn't spelled out plainly in Section 349's text, but the Supreme Court has made it a constitutional requirement. That ruling changed how the State Department applies the law, so Section 349 is not a list of automatic triggers, but a set of potential starting points for an inquiry. The U.S. government can't just point to a routine oath you took abroad and declare your citizenship gone. They must prove you took that oath with the conscious, deliberate goal of severing ties to the U.S. Proving that intent is a very high bar, which is why involuntary loss of citizenship is now exceedingly rare. Section 1. The myth of voting in a foreign election. One of the most persistent myths is that voting in another country's election will automatically jeopardize your U.S. citizenship. This fear originates from a time when U.S. law was much stricter. In fact, before the landmark 1967 Supreme Court case, Afroyim versus Rusk, voting in a foreign political election was explicitly listed as an act that would cause a person to lose their U.S. nationality. The logic at the time was that participating in another country's democratic process was an act of allegiance to that foreign state, and therefore incompatible with loyalty to the United States. This old rule is the ghost that still haunts many dual citizens today. However, the legal landscape has completely changed. Following the Afroyim decision, the act of voting in a foreign election is no longer considered a trigger for automatic loss of citizenship. The Supreme Court ruled that a citizen has a constitutional right to remain a citizen unless they voluntarily give it up. This means the government must prove you intended to relinquish your U.S. citizenship when you cast your ballot. The State Department's current policy explicitly reflects this. It presumes that a U.S. citizen who votes in a foreign election does so without any intention of abandoning their U.S. status. Section 2. The fear of using a foreign passport. Many people worry that entering another country with a non-U.S. passport or exiting another country with a non-U.S. passport or even just possessing one could be interpreted by the U.S. government as an act of allegiance to a foreign power. This fear often stems from a misunderstanding of U.S. travel regulations. The reality is that the U.S. government fully expects dual citizens to have and use foreign passports. In fact, it is often a requirement. For example, if you're a dual U.S.-Australian citizen traveling to Sydney, Australian law requires you to present your Australian passport upon arrival. The key U.S. rule is simple and specific. U.S. citizens must use a U.S. passport to enter the United States. U.S. citizens must use a U.S. passport to exit the United States. As long as you use your U.S. passport when you are coming or going from the U.S., you are free to use your other passport to exercise your right to travel and enter the country of your other citizenship. Section 3. The reality of serving in a foreign military. The issue of military service in another country is more serious than voting. And it is explicitly listed in Section 349 as a potentially expatriating act. The myth is that any service in a foreign military, no matter the circumstances, will automatically lead to the loss of U.S. citizenship. The modern reality is, once again, all about intent. However, there are 2 major exceptions where this presumption does not apply. Exception 1. If you serve in the armed forces of a country that is engaged in hostilities against the United States. The second exception involves voluntary service. If you are a dual citizen in a country where service is mandatory, the U.S. government does not view compliance as an act of expatriation. The situation becomes more nuanced if you voluntarily enlist. Even then, enlisting is not an automatic cause for loss of citizenship, but it could invite more scrutiny. The U.S. government will presume they intend to keep their U.S. citizenship. Section 1. Practical steps and documentation. While the risk of accidentally losing your U.S. citizenship is extremely low, taking a few simple proactive steps can provide peace of mind. One of the most important steps is to always use your U.S. passport when entering and exiting the United States. Another practical step is to keep your U.S. documentation current. Filing U.S. income taxes, if you are required to do so while living abroad, is another strong piece of evidence. It is wise to create a paper trail demonstrating your continued allegiance. For example, registering to vote in U.S. elections via absentee ballot. Finally, think about creating what some lawyers call a contemporaneous statement of intent. If you're about to perform an act that is on the Section 349 list, you can write a simple dated statement for your own personal records. This document, stored with your important papers, could be valuable evidence of your state of mind should your intent ever be questioned in the future. Section 2. When to seek legal advice. While most dual citizens can navigate without legal help, there are specific situations where consulting an experienced immigration lawyer is wise. This is especially true for actions listed as potentially expatriating under Section 349. Seek counsel immediately if contacted by a U.S. Department of State official. Also seek help if a foreign government gives you a document that appears to require renunciation. A lawyer can explain the government's concerns, craft a response, and gather evidence of your intent to remain a U.S. citizen. The goal: move forward with confidence, knowing you've taken the right steps to secure your U.S. citizenship. Section 1. The enduring right of U.S. citizenship. In our journey, we have dismantled the persistent myth that your U.S. citizenship is a fragile status that can be lost by accident. The reality is far more reassuring. Losing your U.S. citizenship is an exceptionally rare event. The core takeaway: intent matters. This safeguard means actions like voting in a foreign election using a foreign passport for travel outside the U.S., working a standard job for another government are not acts of abandonment. Your connection to the United States is presumed intact. Protecting this right is simple, common-sense steps. Always use your U.S. passport to enter and exit the United States. Keep your American documents current. Fulfill obligations like filing taxes. Those actions build a consistent record of allegiance. For the vast majority of dual citizens, the message is clear: live your life. Embrace your dual heritage. Rest assured your U.S. citizenship is a right you keep, not something lost by mistake.